So with that being said, we'll get started, I think, as we, Matt, did you just make sure that he has the link?
I did call him. He said he should be jumping. He said his
Great.
computer was
So
getting
we'll
a
get,
little brief,
no
but he
problem.
should.
We'll get started with Adam. So I'm Mario Capone, Corporation Counsel. I think I've maybe over the years met a few of you. Most of you I haven't, partially because Matt does a great job, and Brian McCann working with your commission. And I think your commission does a really good job, and you have great Alexis. You know, with Alexis, you have first class staff, so it avoids a lot of issues coming to us, which is great. I want to also introduce my partner, my law partner, Nick Lamonte,
Hey
who's
guys.
at my firm, Birch & Moses. So corporation counsel position has basically been part-time with the city, is part-time with the city. So I've always maintained my practice at our firm. By way of background, we do a lot of municipal work, probably the most throughout like Southern Connecticut. We represent a good part of Fairfield County, a lot of your neighbors, Westport, Wilton, Weston, Easton, New Canaan, Westport, the list goes on and on. So it's a big part of our practice. And this isn't the first time we've done this orientation before with a inland wetland or conservation board or commission. So Nick does a big part of our municipal practice. He's town attorney in Woodbridge, and he does a lot of work, land use work for Westport and Weston and Wilton and New Canaan. So pretty much all your neighbors. And he's helped out Norwalk from time to time, and we hope to get him more involved now over the years. And I think many of you know Matt Sapienza, who's the assistant corporation counsel. He is our day-to-day guy on land use related matters when they come up. He generally handles our land use appeal work as well. And so I think some of you may already know him. So we're going to get started with the outline. I think has everybody gotten a copy of it?
No, I'll share my screen though. You want me to share?
All right. So one thing we'll do is we're going to get everybody a copy of the materials. One thing we've done in the past is we've been careful. We don't like to give it out early because then people don't pay attention sometimes to the presentation. But we're going to give everybody the materials, less for following along, but you could follow along, but also so that you have them and for your reference. So if we haven't done that already, Lex, we could email those out. I thought you may have had them, but that's fine.
Yep. I'm
Yeah.
sending
Alexa,
now. I didn't know if I could. That's perfect.
Nothing top
Alexa,
secret, yeah.
To start, I might share my screen. Actually, I might ask you to take over later on, but just for my beginning part, I might actually switch to just another view for a second too. So if I'll try, if I'm allowed to, I might try to share my screen at first.
Yeah, just in case anybody from the public is really bored and wants to is watching, then they could see it as well. So I think Matt's going to
be able to share your screen, Matt.
Yep. Okay. This one. All right. That works.
So we're gonna get started. Again, we're going to be off script, so but you kind of see where we're following along here, and Matt will get us started.
Great. Good evening, everybody. My name is Matt Sapienza, Assistant Corporation Counsel. Again, as another primer just for this outline, it's nothing you have to feel. Please don't feel you have to read every word as we're going. This is a very general outline. As Mario said, we could send you a hard copy, but it's just to give us some structure for the evening. As always, if you have any specific questions, especially as to specific matters or more detailed questions, the best way to ask those is through the normal process where you can ask Alexis to send a request in writing to the law department and we can answer them. And happy just to discuss general issues as well too. But so this outline is just kind of I think it helps Mario, Nick, and myself even more just to keep the structure of the talking points. So let's start at the beginning. You are a land use board. You are a inland wetlands and conservation combined board, and you deal with land use. The way land use works, just in the law in general, is you really possess an extraordinary responsibility in our government. You deal with one of the most fundamental rights in our country, which is private property. And your office, your board, to a degree, imposes some restrictions on that right. So it's kind of got some constitutional and legal underpinnings that date way back. And it's really the balance of the rights of private property owners versus the powers of the state to protect the health, safety, and welfare of the citizens, and especially some of our natural resources. So there's definitely some lore of really kind of fundamental legal and core and constitutional issues. So most of your work, your board will be governed by state law. Although, as we'll see later on, there are some glimpses where the actual United States Constitution itself, federal laws, and our local inland wetlands regulations also kind of come into play as well. I do see a hand
Yes.
raised. I don't know if, or go ahead.
Yeah, I was going to say something. We see a hand raised.
Yeah, I just have a question where you say like balance the rights of property owners versus health and safety of citizens. I think the act was a little bit more specific also about, protecting the natural resource, which abstractly benefits
That's
water supply, life, and generally, sustainability of our living systems.
very correct. Yes, the health safety is a little broad, and as it applies to your commission, it's a little more focused on the resources. And you're right, that's how it connects to the health and safety. Very, very good. Yes, thank you.
But not to an unrestricted extent. Like, yes, that is in the statute, but there is a limit to how far that authority goes, which I will get into. Let's sort of let Matt keep going, and we'll go from there.
Thanks. This collaborative approach is the best approach. So let's just start with your board's kind of underlying legal underpinning. So you are a combined board of inland wetlands and conservation. I think this tonight is more focused on inland wetlands, and that's probably the busier of the two aspects of your agency, and the one that kind of has more legal implications. But we'll just cover both to make sure we are starting this kind of from the ground up. So the city of Norwalk has a combined inland wetlands conservation commission. Some municipalities have separate boards. The concept of a combined board really just means that the same members can make up each board. But really all your powers in the way you kind of execute your day-to-day meetings and as issues come before you, you're kind of wearing one of two hats before any application comes before you. You're either wearing your inland wetlands hat or your conservation hat. And I have a feeling most of your applications and issues are probably inland wetland related. But the Inland Wetland Agency has kind of its own set of statutory enabling statutory laws and ordinance laws, and as well as the Conservation Commission has its own separate category of laws and powers. So there's not usually too much confusion between the two, but it's just helpful to keep in mind that there are two kind of separate functions. So we'll start with the Conservation Commission, which is usually maybe a little bit simpler. But the Conservation Commission is established by Connecticut General Statute 7-131A, and that's codified as well in Norwalk Code Section 35-1. So we won't spend too much time on this, but I just want to show you what the statute talks about. There's really only one statute that directly deals with the powers and duties of the Conservation Commission. And this statute suggests some of the powers of a conservation commission include conducting research as to the land areas of municipality and coordinating with unofficial bodies in order to determine the proper preferable uses for those. It can look for greenway plans as far as a conservation and development plan. It also can keep an index of all open areas, publicly or privately owned. And it may from time to time recommend to the planning commission or to the chief executive of the municipality certain programs and developments for the use of that area. It can also make recommendations to zoning commissions, planning commissions, wetlands agencies regarding proposed land use changes. And it may, with approval of the legislative body, acquire land easements in the name of the municipality. So I won't just read the statute over to you. It's here. I'm happy to send you a copy if you don't have one for yourself, but that's the gist of it. And as you can see where it starts, where a town or a municipality may vote by the legislative body to establish a conservation commission. So the city of Norwalk has done that. And pulling up now slowly is the city of Norwalk's ordinances. And we are in chapter 35. As you can see, it's called the Conservation Commission. And if you look at the powers and duties associated with that, you'll see that
We're just looking at the memo, so just so you know, we're not actually
it hasn't
seeing
changed. Okay, thank you for I don't know if I could change.
By show of hands, how many of you read the ordinance on regarding your commission?
Good question.
Good. I'm glad I only see one hand. I would be scared. I'd be more concerned if all of you raise your hands.
Okay, just gonna change the view here. So here is, and we're able to see this. So when I was talking the statute, no one saw the statute that I was looking at.
No,
That's fine. Okay.
but
well,
we were listening really attentively.
We heard you. We heard you though.
Okay, awesome. So here's the city of Norwalk statutes. As I said, we are in chapter 35 is called the Conservation Commission. And again, the powers listed in this pretty much mirror the statute. So again, Conservation Commission isn't usually the bigger issue, but it's important just to know, your fundamental enabling statutes and laws. And as Mario suggested, that if you haven't read those, it might be just worth a quick glance. So the statute at issue is 131A, and then you can also refer to our municipal ordinances at chapter 35. We'll tell you about the membership and how appointments and your powers and duties.
And by the way, the orientation materials are intended, when you get a chance at some point, try to read, after this session, maybe just read them again. And I think they'll, I think it does. The materials do a decent job of summarizing what your powers are. I think you'll find it, the materials to be, it's not a long read. It's about 8 pages. I think you'll find it to be helpful.
Yep.
Matt was a better student than me. He would read the ordinances and statutes as well. But I think our summary does a pretty good job for you.
So
Nick?
what Mario is saying, after we give you all our presentation, reread the materials, and they may make a lot more sense. Maybe twice over. So
as if you didn't have enough homework to do.
yeah.
Go
But no, like Mario said, there's not that much here, guys. So keep going, Matt.
And that pretty much is the bulk of the Conservation Commission. And your other hat that you wear, as we mentioned, is the Inland Wetlands Agency. And I'm going to let Nick tell you a little bit more about the powers and duties and scope of that.
So thanks, Matt. Hi, everybody. Nick Bamonte. I am one of Mario's partners at Bertram Moses out of our Westport office, but happy to assist here. We do similar representation for lots of municipalities in Fairfield County. So just par for the course here. So as Matt said, obviously, you're the Conservation Commission. You're also deemed the Inland Wetlands Agency for the town of Norwalk. That's set up and established technically under a separate section of the statutes, which is 22A-36, and what follows for those attorneys in the group. And then there's an analog to that in our Norwalk City Code in, chapter 60A-1. So the roles basically that we have approved locally mirror the statutory authority for an inland wetlands agency. And really, the authority that an inland wetlands agency has is to determine whether there's some sort of impact within a regulated area. And regulated area in wetlands terms is a moving target, as many of you know. And it depends on what a soil scientist finds at the time of an application. So this is something that you folks, as members of this board, this commission, when you have an application for a permit for activity in a regulated wetlands area, there should always be a soil scientist report. Sometimes it comes from the applicant, but we also have authority to ask that the applicant pay for a neutral third-party soil scientist as well. So just keep in mind here, what is a wetland and what falls within the boundaries of a regulated activity subject to your review is a moving target. It always is. That's nature. So that's one key thing I want to point out. And then if there is an impact that you think this proposed development is going to give to this wetlands area, then that is fully within your purview to grant a permit or not. And the cases, go in several different dimensions. And we encourage you, if you anticipate or are thinking you're going to receive an appeal on one of these types of applications, you consult with the law department beforehand, and we can have somebody sit in on the meeting. We can have someone guide you through this with all the more nuanced thought processes that this board should be thinking about. But
I think, by
that's
the way, just to jump in for once, I think
Yeah.
your board's fortunate. You've got a director whose experience has been around for a long time. And I know she gives you a lot of guidance as to what you could be looking at, what you should be looking at. And so you're fortunate. Not every board and commission that we go to has really good staff. And when you talk about inland wetlands, I think it's particularly really important to have good staff, because you do get into some more nuanced issues, particularly about, wetlands, what you can look at, what you can't look at. I had this issue come up in Greenwich, where, I was on one side, applicant was on another, about what the commission should be considering with regard to potential wetlands on a property. So I don't think you get a lot of contested cases like that in matters like that in Norwalk, but you're fortunate that you've got staff to give you really good guidance. And to the extent that staff has questions, they could come to, Matt, myself, now Nick, and we're happy to give further guidance.
100%. Thanks, Mario. Yeah, agreed.
And by the way, also keep up your streak of not a lot of appeals. So
Yeah, please.
keep
by all
doing
means.
keep doing the good work that you're doing, which is, again, I think staff's doing a good job of making sure you're not getting into areas that you shouldn't, because the litmus test is we're not getting sued a lot. So I'll knock on wood somewhere. I just want to make sure you don't jinx us, but you've been doing, your commission has for a while now been doing a good job in that regard.
Yeah, agreed. Thanks, Mario. Just because we're like offering this training right now doesn't mean you folks need it. So, I mean, we offer this to all of our municipal clients, and since we were just recently officially retained, this is one of the options we want to offer to all our land use boards and commissions, if not others. So, so that's where we're coming from, obviously. And for your purposes, again, I'll just come back to the main point I want to drive home is that if you receive an application for a permit, which means it falls within or close to a regulated area, here's the terminology that a court will use. They need substantial evidence to uphold your decision. That does not mean what you hear in Law and Order beyond a reasonable doubt. Substantial evidence means you make a reasonable, justifiable decision based on the evidence that you receive as a board during the proceedings, which means when you have opened up and announced that you've received an application up until the point where you officially formally close the public hearing. Because a public hearing, there is some discretion to your board to call a public hearing if you believe it's in the public's interest, but also if it is clearly within a regulated area that requires a public hearing. But it's always within this board's option to call for a public hearing if it feels, as a whole, the issue in front of them is in front of you is significant enough to warrant public input. So that's a big point here. Let's not skip over that. You can receive public input on an application that you think warrants it. Okay.
What is Alexis, what is kind of your standard, I think, with regard to what you're doing with calling public hearings?
So we do have kind of a 3-tiered permit layering of our administrative permits, obviously, our minor permits, and then the 2 application types that come before the commission are intermediate and significant. So any significant is required to have a public hearing, and so all significant regulated activities automatically have a hearing, and then if there's any indication of public, if there's an intermediate application that doesn't fit into that significant, and so generally it's staff that's making the determination of an intermediate versus significant regulated activity based on the scope and the proximity of the activity relative to wetlands or watercourses. And then, so if they have an intermediate application, and if there's any,
which is not unusual.
Yeah.
Alexa, not unusual.
Right. Not unusual. If there's any public interest at all, I generally let the commission know that I've received calls or emails about an application, and then they take that into consideration and usually talk about it and determine whether that is enough to indicate that it's within the public interest. And sometimes, often they end up holding a public hearing with any indication of kind of public interest. So
right.
It's kind of those 2 things. Either it's truly a significant regulated activity, or there's indication of public interest.
Thanks, that makes sense. And that is, I'll just say, the typical practice that I see throughout our municipalities. Matt, or Mario, you want to jump in on just inland wetlands before I move into just FOIA cautions?
Yes. So I think Matt, well, I think you were going to do FOIA, and then I was going to circle back. Yeah, I think you were going to start with do FOIA, and then I think Matt was going to jump, or you were going to jump in with the pub. I think you were going to do FOIA, and then I was going to jump in with conflict of interest and bias and determination, right?
All right, so let me keep going here, guys. So FOIA. You've heard it before. What does it mean? Freedom of Information Act. It is a specific section of the Connecticut state statutes, which says you, as a board, are a public agency. So what does that mean? That means you're subject to the two main requirements under FOIA, because I'm not going to call it Freedom of Information Act every time I say it now. Under FOIA, there's two main obligations for public agencies. One is making your records available to the public if they ask for them. That means whether you have a town issued email account or not. The second is to have your meetings open to the public. And sometimes that's where we butt into concerns more often than not. I mean, sure, we always get FOIA requests for records. So I will just reiterate, hey, if you are doing business on your town email accounts, if you are texting about town matters, if you have a voicemail on your phone related to town business, your personal number, that is all discoverable. And we cannot protect that. So as a public official, you have accepted this role. This is part of the package here. Your communications are now subject to FOIA. Are there exceptions? Yes. There's about 28 of them. And they get very nuanced. Most of them I do not like using. And I will advise most, if not all of my boards, forget most, to be as transparent as possible. So what does that mean practically for you folks? That means any emails you send, if a member of the public asks for them, they can receive them. If it means a member of the public says, you folks have had an illegal meeting because you've traded emails amongst each other, they would be within their right to bring that claim. Because under the definition of a meeting, under FOIA, which requires public notice and an opportunity for the public to attend, not necessarily comment, but at least attend. How FOIA defines a meeting is as easy as a back and forth communication amongst a quorum of this board, amongst a quorum in FOIA terms of a public agency, which this board is. So what does that mean? It means, can you have one-on-one conversations? Maybe. I don't recommend it. Can you have 1-on-3 conversations and back and forth? Absolutely not. So this is not the most settled area of the law, but we see it constantly utilized as a weapon We constantly see FOIA abused. And so this is why we do these trainings. We caution you guys to, when you see an email, do not start replying all. Do not start trading emails. Do not start posting something on Facebook. Do not talk to the media. Mario will get into this shortly after me, but it just leads to worse consequences. Point for my purposes is a meeting is under FOIA a back and forth conversation in email amongst all of you folks. And that's where we get stuck. So be very wary. It's okay to receive an email that staff will send out on the agenda, on timing, on, hey, can you guys make this at this time? That's okay to respond to. But when you start responding to substantive elements listed on the agenda, that creates an illegal meeting that will get you in trouble. So just want to clearly highlight that precautionary tale because I have dealt with it and continue to over and over. I mean, just quickly here, I know we're at after 7 now. Well, we're doing good on time. Okay. All right, I'm just gonna look at our outline here. I think I hit a lot of my main concerns here. You could look through the rest of our outline. Obviously, there's certain timing obligations that have to be met that staff will make sure you guys do meet. But when you do get to a public hearing, that's really the main event. That's the opportunity for any folks to come in support of an application that's pending before you or in opposition. And there's a few different variations to how someone may come in to oppose, one of which is under this fairly nuanced statute 22A-19, which we'll talk about just very briefly later, because that gets into a whole other can of worms. And for those of you who have been on the board for a little while, you may be familiar with that in the term intervener. So I think we can probably save that for another day, but it is a significant piece of how this board, as the Inland Wetlands Agency, must operate if they're faced with this sort of an application. So we'll save that, I guess. Site visits. Sorry, does somebody want to jump in there?
No.
All right, so just things to keep in mind. Site visits, if this agency, if this board wants to go do a site visit, that does, again, if there's a quorum of members, it constitutes a meeting under FOIA, which means it has to be noticed. You need to allow the public to attend, and you somehow need to take minutes. So although we don't say that site visits are prohibited, they're not. Staff has to keep really tight strings on any instance where a site visit does happen, because there shouldn't be any sort of conversation. It really is just observational for the purposes of the folks who are on the board, that they can then report back at a public meeting when a final decision is made on the record. So I guess my piece on site visits is just be careful. If members want to go out and do a drive-by one by one, fine. But once we start straying into territory where there's a quorum, again, a majority of members who are showing up at a site and starting to talk about it, that raises concerns for me as your attorney.
Yeah, I'll just say that our staff generally avoids site meetings or site
For good
visits.
reason, Alexis. I mean, that's why.
Actually, no, I don't think we haven't had them in a decade.
So I'm not suggesting them. By all means, do what Alexis is saying. You know, it works well. And we
Thank
don't, I mean, we don't see them. It's not like this is something different for you guys. Sure, if you want to do a drive-by by yourself, fine. But site visits typically are not encouraged for exactly the reasons that Alexis and I are intimating.
Right. Although I encourage, I mean, I let applicants know that commissioners may knock on their door, and that,
Sure.
you know, you're always encourage the commissioners to go look at a site, because it is informative, but to not.
Of course it is, sure. And if you go and knock on the door and they're like, sure, come on down, by all means. But maybe, Alexis, that's a more often experience that you see down in Norwalk.
But you also have to be careful, you know, you don't want to talk to an applicant about the project. And quite often, when you're doing a site visit, I've served on a board before. Inevitably, if a property owner sees you there, they may want to engage you in discussion about the application.
They're
You have to
going
be
to.
careful to say, yeah, I can't talk about the pending application. We'll get into that in a moment anyways, in my next section.
Yeah.
Actually, I don't mind picking up for the post hearing and record if you want, Nick. Or,
Sure.
Yeah, go for it, Matt.
Done with site visits. So the next few sections kind of talk about the process of the hearing, and I think one of the most rules, and Mario will touch on this in different aspects too, but it's kind of the constitutional law for how the hearing is conducted is the rule of fundamental fairness, and there's a few different avenues for that, but the short answer is that the applicant and the opposition should be entitled to at least comment on all the aspects of the commissioner's decision making. So that's why one of the rules is after the public hearing is closed, new information should not be permitted into the record. So once you close a public hearing, you should not be taking any more emails or information from the applicant or opposition. There's some legal support for technical information, quote unquote, that the board requests. So, and that's usually, you know, maybe experts who the agency retains, or in some instances, legal opinions as well. Ideally, you'd get all this information before you close a public hearing. But again, you can't get this information from the applicant or from the opposition. But if the board retains its own kind of expert, sometimes some of that technical information could come in after the public hearing. But again, you should always try to get it in while the public hearing is still open, because the goal is to let the other people, let the applicant and the public address it. And that's kind of the most notable point of fundamental fairness. And so all these, everything that's going to happen during the public hearing and your deliberations and the information you review is part of the record. And so again, the goal of fundamental fairness is that everything you're really substantively relying on in coming your decision, the applicant and the opposition should just be able to be aware of it and comment on it if they want. So that includes if perhaps you were to do one of these solo drive-bys or if a property owner talks to you, which you should avoid, and Mario will talk about ex parte communications. But you know, one way to possibly cure that is to address at the next meeting, the public as a continued public hearing, and tell them what happened. So you could relay it, and that way other people could have a chance to address it. If you have personal knowledge of a specific site, that's really going to affect your decision, perhaps raise that and let people know. So again, the applicant and the opposition can address that big element of personal knowledge. But again, that's people sometimes it seems like I get the request for kind of a hard and fast rule. Do we have to accept this or when do we close the public hearing if we're still looking for information? And there could be more specific answers based on the facts that you present. So as always, you can reach out to counsel, your law department, for a specific application of this. But the gist is that it's got to be a fundamental fairness, and everyone should have an ability to comment on that. And that's why closing the public hearing before all the information is received is not a good idea, because then again, people can't comment on that. But so the usual order of a public hearing is the applicant presents their case, and then the opposition kind of presents their case, and then most boards do give the applicant a small bit of rebuttal. And where this comes up is sometimes the applicants in the rebuttal start introducing brand new information. One thing you might want to allow is if something, the rebuttal is kind of supposed to just be a summation of the applicant's presentation and maybe address a few of the comments, raised during the opposition. But if the applicant introduces an entirely new document or an entirely new theory, you might want to keep the public hearing open a little bit longer, so the public in opposition at least have a chance to address the new information. And in that method, it's difficult to necessarily control everything about the public hearing, but you can control, as far as generic time, place, and manner of how people speak. That if they've already spoken once, you could probably prevent them from speaking again, unless, again, as I said, new information is presented and you want to give them an opportunity to address that. Executive session is another area where the board could go in. It's part of some of those exceptions to FOIA that Nick pointed out. I guess we won't go into specifics because, as Nick mentioned, there's many exceptions, and I think there's about a half dozen or so for executive sessions. I don't think too many of the reasons come up for inlands and wetlands, unless maybe there's an appeal. One of the grounds for executive session is if you have pending litigation. We could go into executive session to discuss possibly resolving or settling that litigation. But if the commission were to vote on anything, that vote is public. So the discussion may be held in executive session, but eventually you'll come on the record and you'll vote on the record. Nick or Mario, if I missed anything in that, otherwise Mario, I think we're up to conflict of interest.
I think you got it. So thank you very much. So I have a couple more interesting topics, maybe a little bit more fun. Conflicts of interest, bias, predetermination. So with regard to conflicts of interest, we could talk for a while about it, but we're not going to. I'll just give you the quick basics here, and I think you probably know them already. Conflict. When do you have a conflict of interest? Well, when you determine that that there's the manner in which you're going to treat the application is different because of who the applicant is, then you have a conflict. So if it's somebody whom you have a relationship with, and as a result of that relationship, you feel, I really, I would normally ask these questions. I'd be a little tougher, but I'm not because of who they are, or, I'm going to be a lot tougher because I don't like this person. Then you've got a conflict and you should recuse yourself. Now, the conflicts, again, they exist whenever, for whatever reason, you're compelled to consider the application differently than you would for a different applicant. Generally, the reasons for conflict are personal and financial. So, the clear conflicts: family members, mothers, fathers, brothers, sisters, children, cousins, in-laws, even if you don't like them, those whom you have a business relationship with. So somebody that works at your company, somebody who does business with your company. Basically, and then the trickier ones become, for example, somebody you're not related to, but you're friends with. So what, you're allowed to have, a lot of friends in the community, and you're allowed to, know a lot of people and still be able to serve on a board and commission, not have to recuse yourself all the time. So just because you know somebody doesn't mean that you have a conflict. Just because
Could
you know
be
someone,
it could be a next door neighbor.
yeah, I mean, well, yeah, that's an interesting one. I'm going to get to that in a moment with parents as a conflict with your next door neighbor. But with regard to people, it could be I'm in this point, and Nick is, kids are playing sports stuff. A parent of one of your kids' friends, you see a person at sports, birthday parties, they drop off their kid. That's probably not, doesn't rise to the level of creating a conflict. But if it's somebody whom you have a closer relationship with on a personal level, then you probably do have a conflict. Some of the rules of thumb maybe be, if you were going to get married, or if one of your kids is going to get married, would you invite the person? If someone's going to throw a birthday party for you, with a small gathering of friends and family, would that person be invited? If somebody's that close of a friend, you probably do have a conflict. And I've been there before. I've been on a board where, somebody I was pretty close friends with, couldn't understand why I recused myself. He got really pissed. How could you recuse yourself? Because we're friends, and that's the whole point. You were going to vote for this. It's going to be hard for me to get the votes. I counted your vote. I'm like, that's the whole point. You counted my vote because we're friends, and that means that I have a conflict. I mean, and so you'll be able to figure it out. But to the extent that you can't, anytime you could contact any of us in the law department, either through Lexis or directly with one of us, and we're more than happy to give you our review. I do that all the time for folks. The council members comes up more for them, but I've done it for land use board and commission members from time to time. So feel free to reach out. Whether you have a conflict, that's your decision. I can't make it for you. You have to decide whether you have a conflict or an appearance of conflict, but we're always here to help you, to give you advice. There have been times where I've said to somebody, you may want to consider that you have a conflict or an appearance of conflict. Quite often it's the case is that they'll come to me and say, hey, by the way, do you think I have one? That's more often what we deal with. And it doesn't happen a lot, but from time to time it does, and we're always available to you at any time. Nick raised, the issue of a next door neighbor. That raises appearance of conflict. So sometimes you don't actually have a conflict. Hey, you know what? I'm not going to treat this application any differently because this person happens to be a client of my company, my law firm. But how about the appearance? If they're a really big client of your law firm, you may not want to treat them any differently, but it looks bad. So because it's important that when you serve on a public board or commission, that you maintain the public trust. Our law says, even when you don't have a conflict, and our ethics code says this too, you should recuse yourself for an appearance of conflicts, even if it's not going to, even if based on, the relationship with that person, you say to yourself, hey, I'm not going to treat them any differently in this application process. Doesn't matter. If somebody would perceive, hey, that applicant happens to be a big client of Mario's law firm, how could he vote on it? Then it's at least the appearance of conflict. You should recuse yourself for that. That brings up next door neighbor. Is there an appearance of conflict if it's your next door neighbor? That's a tougher one. I've told people on the Board of Assessment Appeals, that's a little different there. It's not a land use board or commission. If it is your next door neighbor, because it has to do with property value, I probably would say it's an appearance of conflict. I think for land use, it's different. I don't think I would go that far with it, but for Board of Assessment Appeals, it's funny you brought up that example because I've used that before. Is maybe where you potentially have an appearance, even if you're not really close to your neighbor, but they're your next door neighbor. Does it look bad that you gave them a reduction to the house next to you? Again, applies more in the context of Board of Assessment Appeals. But I think for your purposes, where you think somebody could accuse you of having a conflict, you cannot put yourself in that position. You need to recuse yourself. Nick and I, our partner, Ira Bloom, has been doing this for a long time, this municipal work. His rule of thumb has been, if you have to think about it for more than a couple of minutes, you probably should recuse yourself. And I agree with that. But not always. There's times where people think about it, reach out to us and I say, I don't think you have a conflict. And by the way, I don't think you even have an appearance of conflict, but you're being conservative, you're asking, and I think that's good practice. So we're always available to you to answer those questions to the extent that you may have them. Bias and predetermination, when is somebody going to make an accusation that you're biased or you're predetermined to make a certain vote on their application, particularly when you made a public statement? That's when it happens. Now, if the court determines that a member of the commission is biased or has predetermined the application, that is in and of itself a reason to sustain the appeal. It's happened before. I've seen it before. It typically happens when somebody has made public statements, particularly on social media, about an application, or there's been communications that people have said, hey, look, I found these emails with this commissioner and somebody about this application. That's when people get called out on the bias and predetermination. I'd be careful too about spouses and partners. And I've had people say, well, I'm opposed to this, but I'm not going to recuse myself because my wife is going to go and oppose this at the meeting. And I've said, well, first of all, you give up some rights when you serve on a board and commission. So you can't have your husband or wife show up at you. It's bad practice if your husband or wife show up at your commission while you're voting on something and giving their opinion on it. That will create potentially a claim of bias or predetermination for you. And I've had somebody say, well, my wife doesn't listen to me, vice versa. Yeah, but it doesn't look good, right? So I'd be careful about any statements that you make about an application. Best practices, if there's a project coming and it potentially may come before your board of commission, you should avoid making any comments whatsoever on social media.
To the
People can
press
find them.
too. To the press too, because they'll be
Well, that
asking.
goes without question. Yeah, I mean, I think today, in 2024, we say press less because social media almost has become our press to a certain extent, right? But yes, absolutely, the press. Nick's 100% right. And furthermore to that, I'm glad you brought up press. The blogs at the end of an article, on Nancy on Norwalk or The Hour, you comment on something, people will find it.
The
And I've seen it
comment
happen.
section is, trust me, we all look at the comments. That is an avenue we will pursue. So be careful, folks.
And it's happened. It's happened in Norwalk where I've had to say to a commissioner, hey, you've got some statements that I've seen now on social media or on Nancy on Norwalk not about the application before your commission, but about the project. It's going to be before your commission. You have to recuse yourself. It's going to be bias, a claim of bias, predetermination. Well, I don't think so. I'm telling you, you don't have, it's your call. You make the decision, but I don't think you want to be the subject of, your commission losing an appeal because you were biased or was determined that you had inappropriate predetermination regarding the application. So, be very careful about that. It's less the case within the wetlands commissions, based on the people you get on the commission, based on type of applications you hear, but it could happen anywhere, including on your commission. So we want to make sure you're careful about it. Ex parte communications, same. Just be careful. I mean, Nick hit up on this, I think, earlier. Just be careful about conversations you have. It happens a lot during the meetings. You go outside. I remember it was ZBA many years ago. It was in the New Haven area. I had an application and they were outside before the deliberation session and like 3 of the commissioners were smoking cigarettes and they're talking about my application and what they were going to do. And I was like in the parking lot. I'm like talking to my client. I'm like, oh my God, I can't believe they're doing this in front of me. But actually that was East Haven, so it shouldn't be a great shock. Be careful about discussing an application at any time in front of folks, whether it be with just one commissioner or more than one commissioner. It's bad practice. You shouldn't do it. But from time to time, it's as crazy as this sounds, you'll see it happen. Now, you guys don't meet live anymore, right? I assume you're on video.
Yeah,
Alexis?
we're just Zoom.
Yeah. So again, I'm maybe dating myself just a little bit because when the meetings were live, you'd be surprised how often it would happen. Where commissioners would talk about an application and then people would overhear it, or an applicant would start to talk to somebody about an application. I mean, it happened a lot more than you would ever imagine. And And so one of the good things about video is it avoids that. So it's less of an issue.
Well, it still happens. They just turn the feed off.
Still happens, but thankfully not nearly as much as it used to. So that's all I have. Nick, did you have anything else to bring us home?
Yeah, I mean, we'll just mention here at the finale of the outline that everyone will receive, we point out this fairly nuanced section of the state law, 22A-19, which essentially says anyone, you don't have to be in a butter, anybody who feels that this application before your board essentially amounts to some sort of pollution against the natural environment. And those are basically the words that are used in the statute, very broad. They can seek to intervene at your level. So if you receive an application for a regulated activity, technically, under the law, someone can, and we have experienced many instances where someone has come into the proceedings as an intervener and then is able to, similar to what you would typically expect in a application, if you have opponents, they get their day in court, so to speak. This statute gives an intervener under this statute additional rights, which triggers an additional level of approval that this board would need to put on the record. I am not even going to attempt to explain what this trigger is, this reasonable and prudent alternative. It's very complicated. There's several layers to this analysis, and I am more than happy to take more time to do this. But this is sort of the most confusing aspect to anything that comes before conservation / inland wetlands boards. And I think it deserves almost its own presentation. So I will just end with
I'll give a couple. Yeah, I'll just give if I can, just a couple of quick practice tips on it. And first, I'm going to walk over and shut the door because the cleaning people are in my office and they're making a lot of noise now. So sorry about that. Usually, it's when I'm at home. I'm in the office. It's still at work. It's my kids that I worry about. So just really quickly on 22A-19 interventions. If it's a contentious application and someone's opposed to it, a lot of times they'll file the 22A-19 intervention pleading. What's important is that you acknowledge it at your next meeting when you receive one. I'm sure Lexis will give you guidance, but that you at your first meeting that you have since you received it, you acknowledge it. You acknowledge on the record that you're granting them the intervention status pursuant to 22A-19. Essentially, that just gives them standing as to receive the same information that the applicant does. So if reports come in, information comes in, Alexis will make sure that the intervener gets them. I recently had something I posed in Greenwich trying to negotiate a settlement, and I got their commission to make some mistakes on our intervention pleading, and got them to make some procedural errors that gave me some leverage to cut a deal. So don't get caught up by counsel on it. Just make sure it's simple. You just want to make sure that you grant the intervention pleading, or you grant the intervener status, and then they pretty much have the same status as a party in the case. So if you give the applicant rebuttal, I would just do the same thing for the intervening party. But other than that, I wouldn't get too hung up on the fact that they intervened. It's more of a legal nuance, quite frankly. and becomes more relevant when there's a court appeal. Although I will tell you a funny story. Years ago, they amended the statute. It's probably like 10 years ago. And Nick and I are active in the planning and zoning section of the bar and both served in leadership there. Anyway, so legislation comes through that section of the bar, recommendations to the legislature. And at one point, they actually amended the requirements for filing a 22-819 intervention pleading, as well as making the claims in court to provide more specificity. And one of the things that led to it, not the main one, but one of them was there was actually somebody who was smart enough to, every time somebody filed for a dry cleaners, they would oppose it under 22-819. So they automatically had standing as a protector of the environment.
Anywhere.
And then they would, they'd file their court appeal and go to the attorney and say, hey, listen, for $7,500, I'll go away and I'll stipulate. And the person was making a lot of money doing that. So, you certainly don't want folks to abuse it. The idea is it's intended to allow anyone, even if they don't live within 100 feet of where an application is taking place, to be able to raise environmental concerns. So there's good reason for it. There's, like anything, there could be abuse, but anyways, I wouldn't overthink it. The main thing is to make sure that you acknowledge the intervention pleading, you grant them the intervener status, and that your staff make sure to send copies of anything that comes in to the intervener. You do that, and that's about all you have to do with an intervener for the statute.
Agreed.
So I think we did it in about an hour. We tried really hard. Is there any questions before we're done? Catherine?
Hi, sorry, I have a few questions. One, if just going back to the beginning a little bit about the balance between the homeowner, it's more in the homeowner situation and the enforcement actions where we come up with conflict. And it also ties in with the substantive, the soil reports and the substantive evidence and everything of adverse impact. A lot of times you're dealing with homeowners that weren't aware, one, that there were wetland regulations, not necessarily intentionally doing things, but it is a burden on homeowners to pay for soil scientists, to pay for some of the evidence. So what are some of the are we supposed to bring in sources, or how do we balance that out? Because it can get very overwhelming and move in a very much more adversarial direction if we're like, we need to have all this evidence.
Are you talking about when you talk about when someone's an applicant and you're asking for the evidence? Is that correct?
Yeah, and also when somebody is, an applicant because of an enforcement action. They didn't necessarily proactively say, hey, we're going to do these activities. They were then drawn in because somebody reported that they'd done these activities without a permit.
I see. So then you're saying the commission's requirements may involve them getting a soil scientist and doing other stuff that you're saying might be a little expensive for the violator or alleged violator.
Yeah. And then in addition to the soil scientists following up to say, some of these activities, we know we need to understand how substantive the adverse impact is. We know there's an adverse impact, but we need to know what is tolerable.
I think it's a balancing act. I think that in comparison to other places in Connecticut, Norwalk is not onerous on applicants. Definitely, I think some other towns in Fairfield County, I won't name names, would be more onerous on folks. With regard to violators, I was in court with Matt, it was a few months ago, and I happened to be on something else, and he was there for another hearing involving an enforcement matter, and the person that the enforcement matter was against had similar issues of violating regulations in other towns, particularly in one that we represented. And so Matt was saying, oh yeah, apparently this guy has a history. He tries to play dumb, like, he didn't know the regulations. But what I would say is that with regard to violators, again, a lot of times people play dumb, but they knew what they were doing. With regard to applicants, they're filing an application, so they're proposing to do something. They don't have to. It's their decision to apply, and to the extent that the commission needs further expert testimony, with regard to wetlands impact, I think it's appropriate within the for the agency to request it. Again, I've been corp counsel for 12 years now. I've actually never heard of a complaint about costs for any of our boards and commissions that I can remember. Can't say that about other places. With regard to asking for expert help
And some of the
or having to
Doesn't
retain an
it come
expert.
down to you need enough information to make a fair and informed decision, right? So
Yeah,
Yes.
and there's ultimately a cost, and sometimes, and it's really the cost of doing business. I mean, I think in Norwalk we're a little bit spoiled, and that's because we do have good staff, and I think we get away with, because Alexis does a lot, we get away with not having to get an expert as much as other towns.
Yeah.
So I think that when we actually do, there's really good reason for it, and the applicant, I think, is going to have to spend the money to do so.
I'll just add that in my experience representing a lot of the land use boards in some of the smaller towns in Fairfield County, almost all of our towns, if they don't have an express provision in their zoning regulations already, this is just practice. They charge an expert to the applicant. So if they come in, an applicant comes in with their expert, says, hey, we found our wetlands, the lines here. If we don't necessarily believe that, and again, this is other towns, not necessarily Norwalk. I just skim through your regs. I don't see this express provision. That doesn't mean we cannot try to put it in there, but other towns definitely charge these third-party consultant reviews, we call them, back to the applicant.
yeah.
And Catherine, if you're worried about the applicant itself, costs that they might have, again, I think as Mario said, if they're actually proposing to do something, I mean, there is a cost with construction, not only to hire the actual contractor, but just to comply with municipal costs. So some of those, whether you think you're over asking, I don't think you are, from my knowledge, but yeah, there may be costs to do it correctly. If it was an applicant, as you said, that maybe did a violator, that maybe unintentionally violated something. Let's say they took a bunch of soil away. That's kind of up to the commission how they want to order the remedy. I know by default, I think sometimes, and if it's needed, Alexis and the commission or the agency will ask them, in order to put soil back, they need to verify that they restored it back to its original condition. Sometimes that requires an expert. I mean, I guess if they really didn't want to pay for it, the agency could be open to another idea, such as we'll tell you how much to put back and we're going to overestimate a little bit just to be safe. And in that situation, it's up to the agency to determine, well, they don't want to have to pay for the commission as long as they put back a little extra. We can rule that they've complied with the issue. So it's going to be case by case, but a lot of that will be in the agency's hands if you want to try to help the applicant. But I think just as a standard basis, it helps everybody to know, well, have they abated their violation adequately? It just helps in order to verify that if they get an expert. But if cost is too much for them, there are probably some considerations the agency could try to help them with. But
I think there's a genuine hardship, with somebody who's elderly or infirm. I'm sure it's something that maybe, the city could try to address, but I've never seen it happen actually, where there's been a requirement for a third party review and at the cost of the applicant. And certainly if the applicant is a burden of proof, the applicant isn't able to satisfy that burden by not being able to prove something pertaining to where a wetland is. I've never seen pushback where there's been a request from the commission to get an expert to opine on it or to have their expert do work on it. Ironically, what I've always seen is people are very appreciative when the commission says, we need you to do this, because otherwise they're going to get denied. So I've always seen where the commission is trying to say, you should get a soil scientist to do this. Here's what you should do. The only thing I've ever seen is people be appreciative of it, because it means that the commission's trying to give them guidance to help them get where they need to go. Catherine, I think you said you had 2 questions. Was there a second one?
Yeah, the second one goes to that substantive evidence. Like if we're asking applicants to give us for their experts to provide when they say like, oh, there's issues that are summarized around the impact, but then, we're asking for evidence to show how those issues are addressed or rectified. If we don't get that evidence, then is that a grounds for denial?
Could be. I mean, I think, to the extent that you have concerns that aren't addressed by the applicant or appropriately addressed by the applicant, sure, that could be reason for denial. And you should make sure to state it on the record during your deliberations.
And then,
And
yeah, and then just, I noticed that you had like the Avalon case, but you didn't have the River Sound, the 2010 case where they found that, that there was the argument about the frog in the golf course. And so the Inland Wetlands Agency had denied it. And I think the issue with the Avalon one is that they had argued on the line of biodiversity, which is not expressly protected by the statute. But the keystone species, which they made a link between, there's certain keystone species that if they're absent, the physical characteristics of the wetland substantively changes. And so therefore the court found in that case that, that was permissible, that it wasn't on the biodiversity, but it was on the fact that the frog was a keystone species and would be adversely affected.
There was a physical change to the wetland, right?
Yeah, that there would be a physical change to the wetland. So I mean, that kind of updated or, addressed some of the issues I think that you were raising with the Avalon case. So I didn't know if you had a,
we're careful with an orientation like this not to get too in depth on issues, to be
yeah,
frank with you, especially with like case law review. But if you guys, if you want to talk to Alexis or reach out directly to Matt, if you want us to follow up on any specific issue with regard to the case law, we're more than happy to do so. I think we just try to keep it, kind of at a certain high level where we don't really
Talking
get into the
points.
detail. Yeah,
Talking points
but-
that
yeah, I
we're-
was just saying that there's more recent case law which might impact on some of the,
But we're
points.
always looking to improve the memo, so we'll definitely take a look at that and see, try to fit it in there going forward. Thank you.
I think it comes on a case by case review though, when you've got specific issue pertaining to for example, a specific species and what is the applicability under the statutes or under our regulations. Alexis?
Nope. Just
Okay.
misclick.
Oh, I thought you had a hand up. But I think you can't plan for having to review every issue that can come up in an application. I think when one does and it's very specific with regard to like the example you've given, I think it becomes something you want to review on a case by case basis. And I think that you want to ask your staff, particularly Alexis, for assistance, technical assistance when those issues come up. And certainly she could reach out to the law department and we could provide further analysis of the law.
Yeah, I mean, I'll just echo that. I mean, this board in particular, as we've said before, literally sees things on a case by case basis because the wetlands constantly move. So, yeah, I'll just echo Mario. I don't think there is any size fits all. We have some basic framework to the law that we try to work within in our conservation inland wetlands context here. But it's not like we have black letter guidance on every situation that we're going to encounter, like you've just described.
But again, on a case by case basis, we certainly could provide further analysis. Were there any other questions before we're done?
I'm gonna regret asking a question this late at night, but first, thank you for your
Our
presentation.
pleasure. Thank you.
My question really is, and if this isn't appropriate, please tell me so, but I always wonder what like the recourse is for applications. If they go through, they've been denied, they resubmit. and then what? Where does that end? Like, and for smaller ones, it doesn't seem to be an issue. For larger ones that maybe have not complied with their measures to fix what they were supposed to fix over the years, is there recourse? How does that?
You talking about like an enforcement action where somebody has violated the regulations?
Yeah, I am. Or they violated they never started, they never did anything with it.
Sure. On enforcement, we do our best. We are generally reactive on enforcement in the city, as are most other communities.
Yep.
We're not going around and doing proactive enforcement and saying, where do people have violations? It's generally based on somebody's filed a complaint and we become aware of it. And then, there's a process that we have or that the department has with regard to enforcement, and eventually they could get the law department involved. And we generally take it on a case-by-case basis. Once we, once an enforcement matter is moving forward. Alexis, I mean, you may be in the best position to talk about that briefly.
I can help you a little, Alexis. I know one is
Yeah.
eventually for the severe violations, Alexis would bring it to me. And I think most of the time, eventually the law department would have to file, I guess, an injunction is the most direct method. A lot of times it hasn't come up too many times, but a few discussions, sometimes the threat thereof has, I think, resolved a few cases that once you give your order and it's not complied with, really the next step, I guess, is Alexis relays to the law department and we file an injunction, which is kind of a lengthy and labor intensive process. And quite honestly, it could take it takes us a little bit in terms of weeks and potentially a month after, we have to get our whole, all the evidence, the records before we could file it. And sometimes the court system isn't always fast. I mean, there is a small method for a temporary injunction. If there's kind of just an imminent thing is about to happen, the court can issue a temporary order. But ultimately, the final resolution of the case could take almost a year to a year and a half. So it's a lengthy process, but eventually for the bigger violators,
The interim approach could be, for instance, where folks are just dumping a bunch of stuff, lawn clippings, into the swamp in their backyard. There is another approach that from an enforcement perspective, and I know we're getting tight on time here, so I'll only spend 30 more seconds. You can enforce through the zoning department a violation if someone is doing an activity within a regulated area. That is an enforceable action that can be enforced through the zoning department. Like Matt said, it can eventually get to an injunction filing with the court. But before that, we get there, we can, and I have sent out, it's not a cease and desist that the zoning department is typically used to sending out. It's a cease and correct, meaning get your crap out of there that you just dumped in the wetlands. So, that's sort of an interim. Let's see if they want to play nice here before we file something at court. Point being, we do have enforcement options. Luckily, it doesn't sound like it's the biggest issue for your guys. Hopefully we stay there, but it is an option.
Okay, good to know. I just like to know but what then?
Of course.
voluntary compliance is ideal, but if
Right.
there's really someone persistent, we do have it takes a long time, but it is ultimately effective in that the property owner can lose their property. It takes a long time for that to happen, but that's
And we
the
haven't
long.
filed any enforcement injunctions in a while, actually, since I think Attorney McCann left. But everyone that we had filed previously was successful and ended up with compliance.
Yeah.
And we are getting, it's on my list of things to do is just send Matt that we've exhausted all administrative means of enforcement. So
That's testament to how, kind of realistic and down to earth the commission is, as well as Alexis, that a lot of these are working out. But for the ones that aren't, we're here to support you.
Alexis, how much did you pay these guys? They've been saying a lot of very nice things about you.
I don't know what they're drinking.
Not, I could tell you not enough.
No, it's true. She's wonderful.
Not enough, that's true.
Well, thank you very much. We're always available if you ever have other questions, and we hope you found this helpful, and we'll try to do it again at some point in the next year or two. So thank you very much, everyone. We really appreciate it.
Thank you.
Thank you very much.
Great night,
Really
everyone.
helpful.
Thank you.
Thanks.